Good morning, distinguished guests, faculty, students, and community members. Thank you all very much for joining us here this morning for the Road from Kampala conference. My name is Kris Leefers, and I'm the Vice President of the Duke chapter of the International Criminal Court Student Network. And today I have the great honor of welcoming all of you and of opening our first panel this morning. The Road from Kampala conference is an analysis of the review conference that was held in Kampala, Uganda in May and June of this year. In Kampala, delegates of the states parties to the Rome Statute, which created the International Criminal Court, met to review the statute and to define the crime of aggression. After a great deal of hard work and compromise, a definition for the crime was agreed upon. Today, we will go one step further to discuss the implications for this new definition, what it means for the states parties to the Rome Statute, what it means for the court's goal of ending impunity for the gravest crimes, and what it means for the entire international community. I would like to thank all of the donors to this conference. Without your generous support, this conference would not be occurring today. I would also like to thank the hard work and dedication of the Duke ICCSN. You have all dedicated a massive amount of time and energy to make this vision into the conference that we have here today. I would now like to introduce Professor Madeline Morris, who will moderate the first panel today titled The Definition of Aggression, History and Future. Professor Morris is a Duke Law faculty member and has extensive knowledge and experience in international criminal law. Professor Morris has served as a member of the U.S. Secretary of State's Advisory Committee on International Law, as an advisor on justice to the President of Rwanda, as a special consultant to the U.S. Secretary of the Army, as a senior legal counsel in the Office of the Prosecutor for the Special Court for Sierra Leone, and as an advisor to the Special Prosecutor in the Republic of Serbia. Please join me in welcoming Professor Morris and the first panel.
Thank you, Kris, and thank you to the ICCSN folks who put this together. Looks like it's going to be a really wonderful and informative conference. Just getting ready for it has been terrific, so reading some of the materials has been wonderful, at least from this panel. So enjoyed that. I'll start by introducing the members of the first panel, and then we'll give some background as I've been asked to do. Our first speaker will be Klaus Crest. He is professor for criminal law and public international law at Cologne University, where he's director of the Institute for Criminal Law and Criminal Procedure, and the chair for German, European, and international criminal law, as well as international and peace and security law and the law of armed conflict. After serving in the German Federal Ministry of Justice, he has since 1998 represented Germany in the ICC negotiations. He's acted as war crimes expert for the Prosecutor General for East Timor, as head of the ICC's drafting committee for the regulations of the court, and as a sub-coordinator in the ICC negotiations on the crime of aggression. Professor Klaus will begin the panel's presentation by outlining the most significant and difficult issues that confronted the conference with regard to the crime of aggression at Kampala. Jutta Bertram-Nothnagel will be our second speaker. She serves with the International Association of Lawyers as Director of Relations with Intergovernmental Organizations and as permanent representative to the UN and ICC Assembly of States Parties. For several years, she served as leader of the Coalition for International Criminal Courts Working Group on the Crime of Aggression. She's represented non-governmental organizations at the UN since 1992, served as president of the UN Association of New York, and has held academic positions at NYU's Center for International Studies and the Cardozo School of Law. She'll be addressing the bases for individual criminal liability for the crime of aggression. Then, as our final speaker on this panel, we'll have Professor Noah Weisbord, who teaches at Florida International University's College of Law, where he's also the first fellow at the School of International and Public Affairs. For the years 2008 to 2010, we had the pleasure of having Professor Weisbord here at Duke Law School as a visiting professor, and it's a pleasure to have him back again. He served as law clerk to the chief prosecutor at the ICC and then as an independent member, as an independent expert member of the ICC's Special Working Group on the Crime of Aggression, and was involved in that capacity at the Kampala conference. He'll complete the panel by examining the adopted definition of aggression in terms of the principle of legality, that is, the requirement that penal provisions be defined in advance with clarity and precision. Then after the panel presentations proper, our two experts, Sébastien Jodoin and Jennifer Trahan, will offer comments on the presentations before we then open up for a general group discussion, which we should be well prepared for and have ample time to engage. Mr. Jodoin is a fellow at the Canadian, where is Mr. Jodoin? Ah, fellow at, I don't want it to be one of those he didn't come things. A fellow at the Canadian Centre for International Justice. He serves also as a member of Amnesty International's Working Group on International Justice, and in that capacity was a member of Amnesty's delegation to the Kampala conference. He worked previously in Trial Chamber 3 and in the Office of the President of the International Criminal Tribunal for Rwanda, and in the Appeals Chamber for the Tribunal for the former Yugoslavia. Jennifer Trahan, thank you, is Assistant Clinical Professor of Global Affairs at NYU. She served as counsel to the International Justice Program of Human Rights Watch, as Iraq prosecutions consultant to the International Center on Transitional Justice, and has participated in cases at the Special Court for Sierra Leone and the International Criminal Tribunal for Rwanda. She's the author of two leading digests on the ad hoc international criminal tribunals, and served as chairperson of the American branch of the International Law Association's International Criminal Court Committee, as a member of the ABA's ICC Task Force, and of the New York Bar Association's Task Force on National Security and the Rule of Law. She served as an NGO observer at the Kampala conference. I've been asked before bringing out our panelists to give some background, and I know that there's a wide range of knowledge base, so you'll excuse me if I'm saying too much or too little. From what I understand, they're going to speak for an hour and a half about one conference, and I'm supposed to trace the history of aggression in 5 minutes. So I'll try. The law of war, as you know, developed in two parts: the jus in bello component about the conduct of hostilities, and the jus ad bellum component that we're focused on today, that is the law.
I'm sorry, I need you to talk into the mic to speak my cast.
What did you say?
You want her to talk in the mic?
Is that better?
Because they're
Okay.
webcasting.
I see.
Jus ad bellum on the law governing resort to force. That is the body of law that one would have violated if one were to commit the crime of aggression. In the early development of the law of war, in fact, not so early, really up until the 20th century virtually, the question of jus ad bellum was really a question of just wars. Whether it was right or wrong to initiate a war was dependent upon the justness of the cause, and not on an underlying general rule against the use of force or against initiating the use of force. Certainly there were peace treaties along the way, the Treaty of Westphalia being the most obvious, where recourse to force was renounced by the parties, but that was always by way of a pact or alliance structure, and not based on any sense that there was, in general, anything unlawful about the recourse to force. It's only in the 20th century that the conception emerged that the initiation of force should itself be made unlawful. The Kellogg-Briand Pact of 1928 itself actually sought to outlaw war for the first time. The original 32 parties to that treaty and others who later adhered declared that they renounced war and the recourse to war for the solution of international controversies and as an instrument of national policy. Shortly thereafter, as we know, World War II began, at the end of which the UN Charter was adopted, again making another attempt in this century to outlaw or to prohibit as a general matter the recourse to force, allowing of only two exceptions, those being, as you know, the authorization by the Security Council for states to use force in order to maintain international peace and security, and the other exception for the use of force by states in self-defense against armed attack. Nothing in the present charter, the UN Charter says in Article 51, shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. 15 months after the adoption of the Charter, the Nuremberg Tribunal issued its judgment characterizing crimes against peace as the supreme international crime. In the years following the Nuremberg judgment, concerns were voiced about ex post facto criminalization at Nuremberg, and intractable problems were confronted, and were for the subsequent 50 years, in arriving at a definition for the future of the crime of aggression. The UN General Assembly in 1974 adopted a definition of an act of aggression, but that definition wasn't intended as and wasn't accepted as forming the basis for individual criminal liability for aggression. The UN's International Law Commission took up the effort, laboring for years to draft a provision that would form a suitable basis for individual criminal responsibility for aggressive war, and met with some success, moved the project along, but still, as the movement towards establishment of an international criminal court gained momentum in the 1990s, the crime of aggression remained problematic and stayed that way throughout the Rome Conference in 1998, the diplomatic conference on the establishment of an international criminal court. Confronted with the ongoing, at that time, difficulties in achieving consensus on a provision on aggression, the participants at Rome, rather than to allow that to prevent the conclusion of a treaty, arrived at the solution that's embodied in Article 2 of the Rome Treaty. That is, that the court shall exercise jurisdiction over the crime of aggression once a provision is adopted defining the crime and setting out the conditions under which the court shall exercise jurisdiction with respect to that crime. It was also resolved at the Rome Conference that proposals for the handling of aggression would be developed by the Preparatory Commission and then considered at a review conference to be held thereafter, that conference, of course, being the Kampala conference that we're here to consider. Between the time of the adoption of the Rome Treaty and the 2010 Kampala conference, two additional complex and controversial issues concerning the definition of aggression came to the forefront. NATO's use of force in Kosovo in 1999 brought forward the question of humanitarian intervention, that is, the lawfulness of a use of force for humanitarian purposes. And of course, that debate has been very much informed, particularly at that time, but since, by the failure to intervene in the 1995 genocide in Rwanda. Secondly, the attacks of September 11th, 2001 starkly posed two issues concerning the legal status of aggression by private actors and the legal status of use of force by states in self-defense against private actors, particularly the use of such force on the territory of a, so to speak, third-party state. So with those newly prominent questions, as well as the perennial problems of jurisdiction, definition, and the role of the Security Council remaining to be addressed, the Kampala conference convened, 5 months ago? And I suppose the question is, so what did you do about all that? Professor Kress.
Thank you very much, Professor Morris. Good morning. I'm very glad to be here again with you in this very nice Duke Law School with wonderful weather and a great team of conveners around. And I'm most honored to make a small contribution under such a distinguished chairmanship as the one of Professor Morris. What did we do about it in Kampala? I have to qualify that question slightly on the definition as such, and this is what this panel is about. Most work, the essential work, had been done before Kampala during the so-called Princeton process. And in Kampala, essentially, the hope was that the outcome of this 5 years of work would meet with the consensus of those around. There has been one important initial element of debate. These were consultations, negotiations with the delegation of the United States that joined the process of discussion at this stage only, and a number of important concerns of this delegations were under discussions, and the discussions resulted in 2 additional explanatory statements, understandings, but the essential result remains that the draft definition that was sent from the special working group on the crime of aggression to Kampala, that it remained intact. And what I want to do in a couple of minutes is to flag for you the main issues and the main decisions that had to be taken in this process of 5 years or so. The work under the most able guidance of the Liechtenstein chairmanship was soon and very usefully divided into 2 baskets of problems as far as the substantive definition is concerned. The definition of the individual conduct, so what actually does a person has to do in order to be subsumed under the definition, and second, what precisely is the meaning of the state component of the crime. And I will deal with these 2 baskets and the set of problems covered by those baskets separately. As far as the individual conduct, and not just conduct and status of the potential perpetrator and participants, the first important thing to note is one peculiarity that distinguishes the crime of aggression from all other crimes under international law, and this is its absolute leadership character. In order to incur individual criminal responsibility for the crime of aggression, you have to be a member of a state leadership. You have to have the capacity to effectively control a state policy. This is a requirement that delegates took over from the old precedents, the key precedents which have been Nuremberg and Tokyo, and there was very little attempt being made throughout the process to challenge the wisdom or the rightness of this basic decision. There have been discussions about how to precisely formulate the leadership clause, and we might come back to this in the course of the discussion. There was, for example, the question whether the language found finally was broad enough to capture also industrial leaders, those that had been, under certain conditions, been included in the range of potential criminals by especially the subsequent Nuremberg trials, a number of them. But this was more a question of formulation. The principle was clear, and this is extremely important because it means in a situation of aggressive warfare, the criminality is very much limited as far as the scope of persons is concerned. The ordinary soldier, most importantly, who participates in an aggressive war and who would, under normal circumstances, under normal criminal law theory, be a participant in the crime, is hereby excluded from the scope of criminalization. The second question then was, within this narrowed range of possible perpetrators, participants, how to define what they actually have to do. And here the principal, or the main question was, I think, more one of technique than one of substance. When the old precedents were set in Nuremberg and Tokyo, international criminal law, its evolution was at a very early embryonic stage, one can say, and what did not exist at the time was a general part of international criminal law, dealing with questions such as attempt, participation, different forms of participations. So the development evolved from the definition of crimes, and then certain aspects were treated as incidental to these definitions, but there was not this idea of having a special part of criminal law with definitions interacting with a set of general principles. And for this reason, there had not been a clear legacy, a clear precedent on forms of participation in a crime of aggression. There could not have been. And the judges at Nuremberg worked with catch-all clauses, participation in one form or the other. The situation had changed when we came to debating aggression, because at that time the Rome Statute had already been adopted, and the decision in Rome was for a general part 3 of the ICC statute, including, as one important component, different forms of participation in Article 25(3) of the ICC statute. The essential question was how to go about this difference in the legal evolution. Should one still stick with the old precedent? That would have meant excluding, more or less, the application of the general part, the new general part, and ending up with a special regime for the crime of aggression also in that respect? Or should these general clauses, in particular Article 25(3), be made applicable? The decision in the end was made in the latter sense, because the overall, or the guiding intuition of most of the delegations was, do deviate from what has been agreed in Rome as little as possible, only to the necessary, the absolutely necessary extent. And if it's possible to formulate a definition by relying on the interplay between the existing general part, do it. So what has been done in the end is, in order to define individual conduct, relying on essentially old language, Nuremberg language, preparing, planning, preparing, initiating, and executing. There is only one little variance to Article 6 of the London Charter. And these formulations then in practice will have to be applied in conjunction with Article 25(3). So within these formulations you have to make, and this will, I think, be quite a challenge for the future judges, you have to distinguish within this leadership circle between primary perpetrators and secondaries. And I will not go into the details because that risks to get rather technical very soon. Moving on to the second and more, well, politically sensitive part, I should say, the definition of the state component. Let me start with those issues that have been reasonably clear within the negotiations from the outset. And that was the decision for a rather narrow definition of the crime. The first narrowness consists in requiring a state act of use, a state use of force in contravention with the United Nations Charter, because as Professor Morris said, at least after 9/11, one could have asked the question, should not perhaps certain non-state acts of force, transnational acts of force, be included into the definition? In this respect, as in many others, states have taken what you may call a conservative approach. They have been staying, and they have taken the decision to stay as closely as possible with the precedents, Nuremberg and Tokyo, and therefore, and this is a second peculiarity of the crime of aggression compared to those other crimes under international law, apart from the leadership clause, the crime of aggression under the Kampala definition presupposes as a conditio sine qua non, as a necessary prerequisite, a state, an illegal state use of force. And the use of military force, there was also very little debate about going down into areas of indirect aggression in the sense of economic aggression. So there were few attempts, and they at no moment in time really had a chance to succeed. So this is a very, very narrow starting point. The decisive question then was how to define this illegal state use of armed force. And there were principally two approaches, and opinions amongst delegates were sharply divided. There was one view, and I hope you will forgive me if I'm not going in all the nuances. I'm really trying to sketch out the basic opposing views. There was one view relying on the General Assembly Resolution 1974 that was already mentioned by Professor Morris, to take this definition, which is more precisely a definition of the concept of act of aggression under Article 39 of the United Nations Charter, and to rely on that definition to define the state act. And there was the opposing view in different variants to have a higher threshold for this substantive definition. And the most prominent position amongst those arguing for a higher threshold was not to rely on Resolution 3314 at all, but instead to arrive at a free-standing definition devised for the specific purpose of international criminal law, and to define the state act, but by what I would call a collective intent requirement. So not under this view, not every illegal use of force under the United Nations Charter would have sufficed, but this illegal state use of force would have had to be carried out for a specific purpose, most typically annexation, and secondly, then perhaps long-lasting occupation and so forth. This was the key problem to agree about, and the compromise finally reached consists in, and you will not be surprised, by a middle way solution. The first component is Resolution 3314 has been used in order to define the state component. There is an explicit reference, and about the details of the reference we can perhaps come back in the discussion. But this reference, and that was key to reach an agreement, this reference has been qualified by what has come to be called a threshold requirement. This threshold requirement states not any act of aggression under Resolution 3314 suffices, but it must be an act that by its character, gravity, and scale constitutes a manifest violation of the United Nations Charter. The purpose of this threshold, and I shall stop here and leave the rest for discussion, the purpose of this threshold is twofold. The first function is a quantitative one. Not every minor illegal use of force is supposed to be covered by the definition, but only the most serious uses of force. And this point has, following the initiative of the United States delegation in Kampala, this aspect has been emphasized, stressed by the two explanatory understandings that I referred to, quantitative aspect. And the second, in my view, much more important aspect is a qualitative one, the qualitative one that deals with a problem also alluded to by Professor Morris in her introductory words, that the primary norm against the use of force that is to be protected by our international criminal law norm is surrounded by an area of significant uncertainty. And it was at least the view of a significant part of the negotiators that this gray area of the existing international law against the use of force should not be clarified through the back door of the international criminal justice system, but that the international criminal justice system here, in the case of aggression, as in the case of other crimes, should only step in once the content of the primary norm is reasonably clear. And this is the second aspect, the second idea behind this qualifier manifest violation of the United Nations Charter. I leave it here. These, to me, seem to be the major decisions to be taken. Whether we have been successful or not in fulfilling these purposes, we can discuss further when we come to the discussion. Thank you very much.
I join Klaus in saying it's wonderful to be here, and I thank you very much for coming on such a great day. Sitting here gives me a lot of hope that you are, maybe like all of us who have worked on this, are working also in the future on peace. And this is what this is about, not so much about criminal law, criminal justice, but about how we prevent a World War III. How we maintain this life on this earth. Don't forget it when we get into all the technicalities. Being and doing are two separate concepts, but they are also very close together. And you see this in the crime of aggression. You must be a leader, but you must do the leading towards this act of aggression by the state. You mobilize the state machinery into an act of aggression. It's these two components together. And yesterday when I talked with several of you, I was just spellbound by your brilliance and by your adventuresomeness, all the stories, what you had already done in your life. And I thought many of you may one day become leaders in your country, and may be in a position, as Klaus said, effectively to exercise control over or to direct the political or military action of a state. Will this definition that we have cooked up over the years assist you in your work as leaders? Will it remind you of the vision in 1945 of the United Nations Charter, that we want no longer go about resolutions of conflicts the way we did before? If you need more markets, if you need more resources, you are supposed to do it under the concept of the United Nations Charter by persuasion, by trade, by agreement, not by the use of force. If you have conflicts, you go to peaceful, pacific settlement of disputes. You go to international arbitration. You go to the International Court of Justice. Only when you are in a situation of individual or collective self-defense or when you have an authorization by the Security Council, you use force. I hope that this definition will always, when you are in these leadership positions, be reminded of it. Let me add a few points to what Klaus has said before. Yes, the leadership clause was very early agreed upon. If you look at 1997, 1998 state proposals already, the leadership clause was already included in it, which reminds me, when Klaus was saying that we negotiated for 5 years, we didn't negotiate for 5 years. We started in 1995, 96 with the ad hoc committee, with the preparatory committee, and then with the preparatory commission. And maybe I could correct here a little bit something what I often read, that we did not do much in the preparatory commission, or that we did not move very far in it. Not true at all. We got very, very far. From the beginning, we had one big mess. The Act and the individual conduct were all in one provision. Belgium then finally suggested maybe we should do a two-step definition, as it was just explained, to get our hands better around it and not to always confuse ourselves with all these different aspects. It was already in the preparatory commission, even before, that the concept of a manifest violation started to come up in state proposals. You had in Rome still a definition that was subject to the determination of the Security Council, subject to. And it took us a while to really recognize that the so-called prior determination would be a post-crime determination, and therefore a violation of the principle of legality. And then Silvia Fernandez de Gomendes in the preparatory commission gradually worked a little bit more of a separation between the jurisdictional conditions and the definition. I recall still in Rome, Germany reluctantly accepted this phrase subject to the determination by the Security Council, but went along in the hope that this way we would get the definition and the whole provision in Rome. But finally, in the 5th or 6th preparatory commission, Germany said, we can no longer live with this, which helped, again, to move us towards a separation of the definition and the jurisdictional conditions. Or when we talked at the beginning about war of aggression or a wider concept, we had at the beginning a Russian proposal which defined it as war of aggression, and this obviously was a very important proposal. But again, there we had in the 5th or 6th session of the preparatory commission a change of heart of the Russian delegation when they suddenly said this had been just a minimum proposal and they would go along with aggression of defining it along the prohibition of use of force under Article 2, paragraph 4. So we have worked on this already a long time. The leadership clause, the early agreement on the leadership clause, played a very important role in the negotiations because it served as a reminder that of doability, that we can do this. We have already agreed on one thing, even if we did not agree on pretty much anything else. But the leadership clause was sort of our anchor that we had something, that we agreed already on something. Later, we added the leadership clause to Article 25, paragraph 3, that was in the special working group on the crime of aggression, where we had long discussions if we needed it there. This is the general principle article about on commission and participation. And so the worry was if we don't put a leadership clause in there, then the provision on participation would immediately pull in soldiers and other non-leaders under the crime of aggression as secondary perpetrators and participants. So then we discussed, do we only put it into 25 paragraph 3? This went back and forth for a while. We had also, still fairly late, discussion if we should use a jurisdictional leadership clause rather than a definitional leadership clause. This was the Chair Christian Venaweser's proposal, and this was in the resumed 5th session, and first it was rather welcome, but then people got second thoughts. We had then the Princeton, subsequent Princeton session. It was very much criticized because people were arguing this, we want it, what kind of message are we sending this way for national legislation? We would then change the definition. It would no longer be a definitional component, and this is not what we want to do. And Christian Venaweser was very quickly coming out with a proposal that then reversed that step and put it back into the definition itself. In the elements, you have now also a little footnote which says that the leadership position can be held by more than one person. Why is this in? You may think we have 25 paragraph 3, we have participation, we have joint conduct in it. But yes, this is joint conduct, whereas the holding of the leadership position, being in a leadership position, is not joint conduct, it's again part of this element which is joint being. So it is a safer approach to remind people of this, that the leadership position can be held by several people. Then you have in the clause, effectively, you are in a position effectively to exercise control over or to direct the political or military action of a state. That came about due to a proposal by Belgium, Cambodia, Sierra Leone, and Thailand, who were concerned about representational leaders, so-called figureheads, who have not really a saying in the political decisions of their country. So that was introduced. It had a double function. This was not the only one. The other one was to remind us of the concept of the leadership clause and provision in Nuremberg, namely that it is not a matter of your formal position, but your actual power, your actual capacity to, now I say, shape or influence. This was the other clause we considered, but it did not come through, partly because we were worried if you have a democracy who does not influence political decisions. In the ideal, we all are influencing the political decisions in a democracy. So we did not move into this area. And one argument of those who wanted this different formula was what Klaus had said, that that we want to cover also the non-governmental leaders, industrialists, the kitchen cabinet. But the understanding, again and again, in the preparatory commission and in the special working group of the crime of aggression, at least according to the chairman, who always said this at this point of the discussions, was that the existing formula that we have covers this too. What about third state accomplices? What I mean with this, you have another state which sends its intelligence agents into the future aggressor state in order to advance the plans for aggression. Can you ultimately then, under the definition as it is, prosecute the leaders of the third state? And when you look at the formula in the definition, you see, and in 25 paragraph 3, it says that you have to be in this position in a state. It does not say in the state which commits the act of aggression. But in the elements, you have it reformulated as the position in the state which committed the act of aggression. So the elements narrow the situation with regard to third state accomplices. You would now only be able to reach them if you can argue that the third state is somehow also committing an act of aggression, or if the third state accomplices maybe reach a leadership position in the aggressor state. I want to talk so much more, and I got this 5-minute thing. But let me just say one thing with regard to the manifest violation. I wanted to talk about intent, because this will matter to you as future leaders a lot. Intent and knowledge. What is it that you need to intend? What has to be your knowledge? And for this, you have to very much think again about the manifest threshold clause. What is typical for a leader who commits an act of aggression? It's not necessarily that they are aggressive people. What in my mind, when I observe this, it is that they use force without caring about the law. They do not have so much an intent to violate the law, but to use force no matter what the law says. You remember still in the Third Reich, treaties are just sort of a piece of paper or whatever. Nothing that concerns me. But wait, what about the concept of a higher law? What if the use of force is a requirement for the enforcement of that higher law? What if the Security Council authorization is withheld irresponsibly? What if it is not the veto holder but the user of force who is Antigone? What if the interpretation of individual and collective self-defense may be shifting? And this is why we put in the manifest threshold clause. On one hand, the factual threshold, and on the other hand, to exclude from criminal jurisdiction the gray area zones of the law, where you can have a reasonable debate and when you can have make good faith errors. I realize I should stop. Maybe we can, yeah. We in the negotiations, this was ultimately accepted by, I thought, the United Kingdom was there very instrumental by explaining to the others. We have also a national law, a differentiation between the evidentiary standpoints in civil litigation and in criminal litigation. So it makes sense to have a higher standard in our criminal litigation. This does not mean, this was also an issue, this does not mean that a state cannot go to the International Court of Justice and litigate a state act of aggression that does not amount to our manifest threshold. But we were saying we cannot put the burden of guilt on an individual in an area that is not so clear, maybe. Now, you got the argument in the last year before Kampala in particular, this is not specific enough, we need to make a specific list of exemptions and so on. But there we would have really had a dilemma. Either you make a list that is too wide, then we run into conflict with the United Nations Charter, or we potentially undermine the concept of the United Nations Charter. If we make it too narrow, then we are unfair towards the leader. So we did this, we were considering lots of different possibilities, and I should maybe add at this time also the French proposal. The French proposal, I think it was in 2007, was, I should say France was the only one under the Security Council members which did not want a manifest threshold clause. They held out very, very long, no, they did not want it. And then in 2007, they finally made a proposal for a jurisdictional threshold clause, that the court would only have jurisdiction if the act has a certain gravity and is large scale. And I remember still Klaus being very angry in a way about it, because he felt there his manifest threshold clause gets wrecked. We have already nearly agreement about it, and now we start with a new formula. I must say I was thrilled. I was very happy, not about the formula, but because it was an indication that France was moving. And they did move, because at the end of these discussions, they ultimately, there was again then the discussion if we should do it jurisdictional or definitional. It's very similar to the leadership clause discussion. What we put in, we ended up, and France agreed. We will do it in a definitional fashion, but insisted in that discussion on putting it in the first paragraph, because their argument was they did not want to affect inadvertently the definition of the act of aggression. I know this is not good what I'm doing right now. I think I end, and maybe we can have a chance later in conversations and whatever, but I want to say, when you become leaders, I hope that this definition and this provision reinvigorates your imagination for peace.
So you're probably getting a feeling now about how intricate and sophisticated the outcome of this negotiation process was. And I'm going to just quickly recap, because I understand that there's experts and non-experts in the group. And then I'm going to open up an interesting criticism of the definition, the fact that maybe it's void for vagueness. And I'm going to give my response to it. And within this discussion about the ambiguities and gaps within the definition, I'm going to open up the possibility that there is, in fact, some leeway for judges with the crime of aggression, like there are with the other crimes, for judicial interpretation, and the judges will soon be faced with an important task when an aggression case ends up in the docket of the ICC after 2017. I guess it's hard to overemphasize the historic problems that this working group of diplomats was facing when they went into the task of trying to define the crime of aggression. And the way that I think about it is that they were addressing three issues, and they were well captured by Jutta and Klaus already. The first one was a distinction between a just versus an unjust war. That's the question that Jutta just dealt with about what is the character of a state act of aggression. So the collective act itself, it takes more than one person to wage a war, and this is what the working group was trying to come to terms with, and what made aggressive uses of force different from permissible uses of force, because not every use of force would be prohibited under the new definition. Self-defense would be one example. Collective security to address a threat to international peace and security as authorized by the UN Charter, that's another example. At any rate, so the working group, including Russia, China, Iran was there, a whole bunch of states, Canada, Germany, were all trying to hammer out in a diplomatic context what would be the distinguishing line between what's permissible and what's impermissible when it came to the collective use of force. The second question was, I guess I like to think about it as akin to Hannah Arendt's question in Eichmann in Jerusalem, is how do we hold an individual accountable for a collective act of violence? Does it even make sense to hold one specific individual accountable for something that took many people to plan, prepare, initiate, and execute? So how do we, and in a democracy where the leaders are the representatives of the people, does it make sense to hold the leader accountable for an act of aggression? So there was a number of controversial issues there too, about how to hold a single person or a group of people accountable for this collective act. That's the question that Klaus was dealing with when he was talking about the individual conduct. And within that concept of individual conduct, there was sub-concepts that Klaus dealt with as well. And one was who within the entire state would be held accountable, and that's a leader, someone in a position to effectively exercise control over or to direct the political or military action of a state. So the working group had to define what a leader is for the purpose of determining who is the aggressor. The other thing that the working group had to look at to connect the individual to the state act was what kind of conduct would amount to aggression. And that was the planning, preparation, initiation, or execution of one of these illegal collective acts. So that's the general lay of the land here. And when it came to the collective act itself, there was a reliance on existing customary and treaty international law as the basis for the line between legality and illegality. And the UN Charter became the main structure that was going to govern how judges are to assess what's legal and what's illegal. Which brings me to the criticism that I wanted to take up, and that would open the door in our discussion to some more interesting questions about what happens with humanitarian intervention. Does that get counted as aggression? And then the leaders of the NATO states that intervened in Kosovo in order to prevent ethnic cleansing in that province would thereby be held accountable. And preemptive self-defense. What about self-defense in order to prevent a nuclear attack on your country? At what point can a state intervene? So these questions relate to the problem of determinacy and indeterminacy of the definition. So recently, my friend and colleague Michael Glennon wrote a piece in the Yale International Law Journal and another piece in the New York Times saying that the crime of aggression is a blank prose crime, that it is too indeterminate to guide individuals' behavior, and thus it violates the principle of legality, and furthermore that it would capture almost every single act, use of force that the United States has used in the last 50 years, and that it would expand so broadly that it would include not only the leaders that made the decisions, but congressmen, senators, anybody, and therefore the whole crime was a failure. It wasn't defined precisely enough. Now, for those drafting the crime of aggression, this was a big attack, and it was an important critique to address. And it's true, Glennon was right, that there are zones of ambiguity and gaps within the definition. These zones and gaps were necessary to build in order to reach the political consensus on the final outcome of the definition. So, over the question of humanitarian intervention, it wasn't clear exactly at what point an intervention of the sort that NATO used in Kosovo to prevent ethnic cleansing, whether that would cross the line into illegality. So there was this manifest threshold, which was kind of built in, which would sort of capture the idea. But the debate was not resolved about whether the use of force in Kosovo was a manifest violation of the UN Charter. So there's a gap within the word manifest about what counts as a manifest violation of the UN Charter, and therefore what counts as a state act of aggression that could attract individual responsibility for the leaders. So Michael Glennon is correct. There are zones of ambiguity and gaps. But where I think he goes too far is that he generalizes too much, and he says that the crime is not specific enough to guide behavior. And this is where I think he's wrong. I think that rather than being completely indeterminate, the crime has some natural gaps that are contained in other criminal law provisions as well. And just to give you an idea about two American criminal law provisions that I think are far more ambiguous than the crime of aggression, which has a chapeau, a definition of aggression, and a list of enumerated acts which count as aggression. So attacking the armed forces of another state, bombardment, blockade, sending armed troops that are not members of a military to attack another state, all of those count as acts of aggression. They were defined in 1974 in the definition. There's specifics to this crime, whereas, for example, the crime of loitering. Let's try to think for a second about whether the crime of aggression or the crime of loitering are more indeterminate. Loitering is to linger or to hang around in a public place or business where one has no particular or legal purpose. Compare that with the definition that you have in front of you, or do you have it in front of you? You do have it. Some people, there's a stack of definitions, okay, which defines aggression with specificity in terms of the conduct, the consequences, and all of the different elements of aggression are well spelled out. Compare that with loitering. In Kentucky, a person's guilty of loitering when he remains in or about a school, college, or university building or grounds, not having any reason or relationship involving custody of or responsibility for a pupil or student, or no other legitimate reason for being there, and not having written permission. That's a law in Kentucky, okay? That's a valid criminal law, and jurisprudence fleshes out the gaps and ambiguities within that law, and that's how the criminal law works. Or take the definition of treason under U.S. federal law. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. What counts as giving them aid and comfort? But we don't object to the criminal law of treason on the grounds that it's void for vagueness. The argument about vagueness does not come out of the blue. That argument itself is not determinate. It's more indeterminate, in fact, than the crime of aggression itself, which is defined with more specificity than the doctrine on vagueness. So I'm going to give you an example. Okay, Michael Glennon says in his article that there's not a clear distinction in the definition between aggression and self-defense. In fact, how it works with the crime of aggression is the law of the UN Charter gets imported by the judges, who then apply the entire doctrine on the use of force in order to determine the entire existing doctrine on the use of force in order to determine the line between aggression and self-defense. There's a whole body of law on this subject. I teach it at Duke, and I taught it at FIU, and I know from looking at the reviews of the literature that there is some indeterminacy about where aggression ends and self-defense begins and vice versa. But it's not completely ambiguous. For instance, interceptive self-defense, characterized by military action in response to an attack that has not actually crossed the defending state's sovereign borders, but nonetheless has commenced. Someone launches a missile. It hasn't crossed the border yet, but it's commenced. A state that's going to be the victim of that missile attack has the right, under charter law, to respond to this attack. There's no question, none of the authorities would doubt that. Preemptive self-defense. This stems from a fear that in the near future, though not in any immediate sense, a state may become an armed target of an aggressor state. The notion is to preempt a potentially escalating military threat. Nobody, if you survey the literature, and there's a good survey by Sadoff, who used to be in the American military, in the JAG Corps, he has a look at all the authorities. Nobody would agree that preemptive self-defense would fall under a justifiable use of force under charter law. It's not proximate enough. The question is with anticipatory self-defense. That's the gray area. It's not complete indeterminacy. Anticipatory self-defense consists of the use of force in anticipation of an attack when a state has manifested its capability and its intent to attack imminently. When there's an imminent attack that's forming at your border, that's when there's some degree of indeterminacy. And the indeterminacy is narrowed still further by the fact that there's a doctrine which is somewhat controversial, but that the judges will probably have to deal with at the ICC when an aggression case comes before it, which was dealt with by the Nuremberg Tribunal, called the Caroline Doctrine, which sets out a test for imminence. And the court, in all likelihood, in a self-defense case, will have to address whether they accept this doctrine or not, and whether an imminent threat and a response to it in self-defense would be counted as aggression in self-defense. But I should not forget, and we should not forget what both Klaus and Jutta had said before, it's only the manifest violations of the UN Charter that are going to count as aggression. So these gray area issues, they're going to be left for some other process to handle. The job of the judges is going to be made easier by this manifest qualifier, and where gaps and ambiguities come up of the sort that I've just discussed, probably what's going to come into play is the question of whether this use of force in anticipation of an attack that's going to occur imminently was a manifest violation of the UN Charter. And who knows what the judges are going to hold in that case. So in conclusion, and just to open it up, and hopefully we'll talk about humanitarian intervention and armed attacks by means other than the conventional ones, such as cyber attacks and systems disruption. I'm hoping we can talk about that later. But for now, I will leave you with this idea. It's not indeterminate. It's a matter of where there are carefully tailored gaps and ambiguities that a Herculean judge will be expected to address and to fill on a case-by-case basis. Is there a button?
We don't have a button.
Is there a button in there?
No.
Jennifer,
You can thumb up, yeah.
Come on up.
Okay, I'm just going to make a few. There isn't a session today on sort of some of the general issues that Klaus addressed in his speech yesterday. So I thought I would touch upon that very quickly, and then it'll sort of connect with what the quick comments I'm going to make. So Klaus, in his speech yesterday, alluded to the position of the human rights NGOs that were not it's actually a rather difficult position to explain, I'll admit. But initially, going into the conference, we were not opposed nor in favor of the crime of aggression. We were neutral, and as the conference went along and the proposals developed, we actually took a position against both Amnesty and Human Rights Watch were concerned. But I just want to maybe explain the basis for the decision to be neutral on aggression, and there's really sort of three reasons. The first is what you would say sort of a very strict legal position about the right to life and its relevance to jus in bello and jus ad bellum. And of course you could disagree about whether it's appropriate for human rights advocates to take a strict position that the right to life in an armed conflict that the lex specialis of IHL applies and that jus ad bellum is a separate issue. You can take a position that might be too conservative a position for an NGO to take. But I think legally, I think it's a sound position. The second main reason, the one that we insisted on more, was this idea that we wanted to remain neutral, so we don't criticize states for the use of force. We work on what happens to the victims after the conflict begins. Again, this is much more sort of a policy, political position that we can have disagreements with. And then finally, and I'll admit, and I'm not saying this in sort of, this is not the official position of Amnesty International in any way, but I will admit that I understand why some would say this strikes them as an odd position to take or a conservative position to take. That's certainly the pushback that we received. And so one of the things that I was thinking about is, why is it that there are these, two rather important human rights NGOs, and that you had this, a lot of NGOs and delegates were asking us, why are you not on board with this? Why are you not supporting this? And I kind of explained the reasons. But what I was sort of curious was, where were the major peace NGOs? Where is the peace movement today as a constituency? And I think that's a separate issue. I mean, you can criticize the human rights NGOs for not supporting the crime of aggression, but you can also ask yourself, where is the enthusiasm for peace today, and why aren't there global major NGOs? And not to say that there are great people working on these things or committed people, but their sort of constituency is actually rather small, or at least their capabilities sometimes seem rather small. And I think one of the reasons is that the sort of enthusiasm for peace has long ago, there's always a lot of compromises, it seems, with the peace movement. It's sort of, well, aggression is a first step for peace, but for all of the loopholes and all of these different things. And, well, we have a prohibition on the use of force, but, well, there's self-defense, and then there's these gray areas. So I wonder if that isn't a problem. And then, sort of looking at on the issue of the definition, if you look at Resolution 3314, I think one of the most interesting things, and I know this is completely unrealistic to think that this could have ever made it into it, but Article 2 says that any violation, any use of the force that's inconsistent with the Charter is a prima facie violation of the Charter, and then you basically have to sort of overcome that prima facie violation to prove that it isn't the crime of aggression. So if you had taken that approach, then you would actually be committing the court to looking into and clarifying all of the gray areas, all of the uncertainties that you mentioned. And you, Klaus, you said that you thought it was a good thing that the court didn't have to do this, that we can't fix the law on the use of force through the international criminal justice system. And I have to say, it's an interesting position to take. The other side of it would be that if you look, and again, you can sort of criticize the ad hoc tribunals for the development, for all of their case law, but you can certainly say that they've played a huge role in advancing, progressively codifying international humanitarian law in a way that many have criticized. But anyways, you can't deny that they've played a huge role in clarifying a lot of the uncertainties. And I think that it's interesting to think about having a court to deal with these issues can be a really positive thing. And certainly, again, working in litigation, we're always trying to use courts to progressively open up avenues for positive change. So that's one thing I wanted to say. And then sort of the two other comments I'll make is, one is I think you're right, Klaus, you mentioned it's going to be rather complicated to deal with liability. And we saw the same thing with the ad hoc tribunals, the complicity, and especially at the ICTR, that you had this crime of complicity and genocide, and it was never very clear how that related to the modes of liability. And I think this is even more complicated here. Can you sort of can you order the planning of the crime of aggression and all these things? It's going to be rather complicated to figure out. The last thing I'll say is limiting it to the leadership position is an interesting decision from a sort of broader how it affects sort of policies or possibilities for peace. And I say this because having worked on cases that involve the right to conscientious objection. But more specifically, a number of those cases, especially in the UK, where soldiers decided that they couldn't go to Iraq because it would be obeying a manifestly unlawful order. So now it's actually not clear, and of course they weren't successful, but the path for that possibility of an individual soldier deciding that they will not engage in a war of aggression, now that this crime of aggression has been limited to leadership positions, it's an interesting question. I'd like to hear what you think, whether this is actually now basically closing the door completely for a soldier to claim, no, I won't go on this war, or unless you have to prove that basically it's a manifestly unlawful order that implies a manifest violation of the Charter. So those are sort of my comments, mostly to you, Klaus. But also, Jutta, I think you might want to react as well.
Okay.
Would you like to respond and then?
I can also wait.
Either way.
Yeah, let's Jennifer. Oh, yes.
Well, that's a hard act to follow, especially given who else is in the room. Just a reminder of what this was all about and the tremendous significance that the definition meant. So we've heard some of the details, but just a reminder, and many of you are probably students of Madeline Morris, so may not need to, the reminder that, of course, jus in bello permits you to kill combatants, and there's certain collateral damage, our euphemism. So there are tremendous human rights costs of aggressive use of war. So this is kind of what it was all about. And I think to some, maybe these negotiations looked very unrealistic. Do we really think we're going to stop the aggressive use of war? But that's what this is all about. And Jutta reminded us that maybe this will remind leaders to look at the definition, because we'll later talk about conditions for the exercise of a jurisdiction, and you will all observe there are going to be gaps in jurisdiction. But yet our hope is that it will have tremendous importance despite these gaps. Having worked for Human Rights Watch, but not doing so any longer, and I know they're not in the room, I can't speak for them, but I will say I did share the dismay of that human rights organizations were not present and were not constructively involved in these negotiations, given the tremendous human rights costs involved. Klaus maybe wants to might want to talk a little more, or I know we have in the audience, we have a member of the U.S. negotiating team, and it just may be interesting for, you're probably mainly U.S. students, to realize that the U.S. wasn't present for many of these negotiations. And this had certain drawbacks, so they came very late in the day. So they might have had different influence on some of this, but that it played out very late. And then just finally to Todd, to Noah. Noah's comments, I think endorsing Michael, or not endorsing, but using Michael Glennon's language of gaps. And I think our whole notion of, in the definition, is the gaps have been filled by this term manifest. And I think Klaus has explained that well, but maybe we'll want to explain a little bit more why we couldn't expressly do a humanitarian intervention carve-out and the difficulties there. Last minute, there were attempts to get an understanding expressly reflecting that. I think that would have been incredibly difficult to do, and why we settled with manifest and not that final U.S. proposed understanding. Thank you.
So, do we comment? Do we answer?
Well, I'm looking around to see whether we have takers. I've got a few questions myself. Yes?
Here or down there?
As you prefer. Yeah, you should be able to be heard by that mic.
Yeah,
they're on. Okay, so then that should work.
Okay, good. I understand this being webcast, so it's important to find
right.
the microphone.
So is it, Ben, is that one on?
I don't think so.
Well, yeah, something is on. So maybe come down and so if somebody figures it out. Be less athletic next time. Introduce yourself.
Sure.
I'm Davis Brown, University of Virginia and Virginia Military Institute. I'm a bit of a disadvantage in that all of you had beautifully prepared speeches and I'm speaking off the cuff. I was not at Kampala, but I was also an NGO delegate to the Special Working Group of the Crime of Aggression, and although I did not see what went down in Kampala, I did see what went down at other meetings of the Special Working Group, and my observation was that humanitarian intervention and anticipatory self-defense, more the former than the latter, from my perspective at least, really were the elephants in the room that everyone was trying to ignore. Or for those of you who have read Jane Eyre, they were the Mrs. Rochesters of the house, in that no one was willing, or very few were willing to acknowledge them privately or publicly, but which put together does actually explain a lot of international outcomes. And so the concerns that I had in the special working group, and which I still have now, are, suppose you're a judge 30 years from now, and you're faced with a situation like Kosovo, or a situation like Idi Amin. One country commits a massive, large-scale use of force in another country in order to depose a flagrant violator of human rights. What do? Well, you've got this manifest violation threshold, but the question you're still left with is humanitarian intervention in that gray area or not? Or if you're faced with a case like the Iraq War, is preemptive defense or anticipatory self-defense part of that gray area or not? And how do you know? And the reason I maintain the second question is a problem is that if you look at the travaux preparatoires, at least that I've seen, that's been made available to the public, humanitarian intervention and preemptive defense or anticipatory self-defense really are not talked about a lot. Very little, and the few discussions that I personally was able to have with delegates of states were essentially all done in private. So how does a judge 30 years from now understand what the intent of the drafters of the crime of aggression were? And maybe this goes to the more fundamental problem, in my view, of the way that the crime of aggression is drafted. And that is that it takes little stock in the intent of the state, or more specifically the leaders of the state, in committing the acts that would constitute aggression under this definition. So I would be interested in how some of the panelists respond to that. And let me also ask one quick other question, as I just simply don't know. Will the position of the United States and the response thereto be discussed later in this conference? And if not, would one of you be so kind as to elaborate on that now? Thank you.
Who would like to?
So we have, he's the
Oh,
US
is it two-finger?
Maybe we should respond before we...
He's the
Well,
rep from the US.
Is it a two-finger response? Plain response? Should we gather some up? Yes, let's do that.
I'm from the United States, from the government of the United States. I wanted to comment on one sort of particular point to clarify the way one of the points that we saw that maybe didn't come out as much in the discussions here. The discussion described how there were two definitions, the state act of aggression and the crime of aggression. And to an extent that I think people on the outside of the government didn't realize, we were very, obviously the crime of aggression, the definition, who's going to be responsible is the ultimate product. But we were very focused on the definition of the state act of aggression, which we had serious concerns about. And the statement is often made that the definition in paragraph 2 of the state act of aggression is based on Resolution 3314, the General Assembly Resolution in 1974. And our considered view was that it was based on it, but it didn't really sort of mirror it. That it took the words of 3314, all the stuff about bombardment and invasion, but it took them completely out of context. And that whereas 3314 listed these things, it didn't actually say that those things were acts of aggression. It was all qualified. and it was qualified by the language in paragraph 2 of Resolution 3314, which I have here someplace, which talked about the other factors that had to be taken into account. And essentially what it said was that it carved out a distance between, it said that all illegal uses of force were an acts of aggression. And the thrust of it is that only the most egregious illegal uses of force are acts of aggression. Forgetting about what's criminally liable, what is it that a state does that is the act of aggression? And we were very concerned about that because judges are going to be interpreting this, and they'll be interpreting, in getting to the decision on who is criminally responsible as a step before that, they'll be deciding what it is that's a state act of aggression. So the definition as we saw it coming out from Princeton going into Kampala didn't really reflect this at all. It said, and it still says, in paragraph 2, for purpose, an act of aggression means the use of armed force, and I think essentially what it says in that first sentence is, means an illegal use of force. It doesn't actually say that, but I think that's what it means. And we don't agree with that. We don't agree that every act of aggression is an illegal use of force. The second sentence then says, it lists these 7, 8 things that are, as far as we can tell, automatically acts of aggression, and we don't agree with that either. We think there will only be acts of aggression in the most egregious cases. And in the words of 3314, what it says to look at are, it says, use of force in contravention of the Charter shall constitute not an act of aggression, shall constitute prima facie evidence of an act of aggression. But then it says, determination that an act of aggression has been committed would not be justified in light of other relevant circumstances. The Security Council in this 3314 framework has to decide, but somebody has to decide. But a determination that an act of aggression has been committed would not be justified in light of other relevant circumstances, including the fact that the acts occurred, concerned, or their consequences are not of sufficient gravity. We went back and looked at the statements that were made in 1974, and these were supposed to, those words were supposed to impute the idea that purpose was a relevant factor to look at, that all these things, and it says, I think a predecessor version of 3314 actually had statements, there was a battle in 1974 about whether to include a statement about purpose. And eventually, it wasn't included because it was sort of too maybe heavy-handed, but it left the phrase in, would not participate in the light of other relevant circumstances. It was broad enough in our view, and I think we made a statement at the time that it included purpose or motive, whatever they called it at the time. So that was a key concern, and I say that here, that is, we tried to address that with the understanding that Klaus was talking about, which puts back in the understanding language. It says, it takes that language. It is understood that aggression, not the crime of aggression, the act of aggression, it is understood that aggression is the most serious and dangerous form of relief, and it takes the words from 3314 and tries to impute them back. Whether that's successful, I don't know. It's hard to know exactly what the court's going to make out of the understandings, but it is precisely that was the purpose of that effort to get that understanding in. I sort of thought I'd share it with the group here.
Let me ask a question about the understandings. How did they go from what seemed like a more explicit statement of what you were seeking, that is, not aggression is the most serious crime, but rather only the most serious such crimes are aggression? I mean, that's right. How did only? It seems like the loss of only was a big loss, and the loss of purpose was a big loss in the understanding.
Well, it's a negotiation process. It's probably the same. It's a mirror of the negotiation process that probably happened in 1974. But we had Klaus led a large group in Kampala of delegates from many countries, and there was a view expressed that, specifically, we explained our language is based on 3314, and one of the delegates said, but that's not what it says in 3314. And the compromise was we'll use the word that's more precisely tailored to 3314. So you're right, it isn't as explicit, but we thought it did a reasonably good job of sort of carrying the idea forward.
It was a
and it's a crucial idea. Yes.
Yeah, and I'm wondering why. I mean, what was at stake, and why was that? Yeah.
Why did they object? They may have been suspicious of our motives.
Yes, please.
Just to weigh in on that, since the 1930s, the Russians have had a position that the first strike should be the determinate factor with the state act of aggression. So that whoever struck first would be prima facie the aggressor. And the Americans, throughout the Cold War, to my understanding, had a position that the purpose of the strike should be the determinate factor. So there's been this debate that's been going on for a long time, and the Americans had better first strike capability than the Russians did during this period. So this might explain why they were taking a legal position that would mean that where the Russians were against having first strike as were for having first strike as the criteria, and the Americans were more interested in the purpose of the intervention. So this debate has resonated all throughout the Cold War. Then it pops up again in Uganda in the working group that Klaus was chairing on these understandings, because the definition could not be reopened at Uganda. There wasn't enough support to try to add in some specifics that the Americans would have liked to have, because it had been already so many years of negotiation over every single word. So the best way to intervene for the US delegation, the way that I saw it, was to try to make some understandings about the interpretation of that definition. I think what Todd's talking about here is why the Americans tried to have some understandings made that the purpose should be the most significant factor, and that only the highest levels of use of force should amount to aggression. That's my little contribution there.
You like to make some closing remarks?
Yeah, I would like to respond to some of the questions. With regard to peace organizations, why they are not in it, that we did reach out, I did reach out to them, but there you have the problem that they are not very interested in the International Criminal Court. They don't like the whole concept of punishment and retribution. They could not get enthusiastic about it. They are concerned very much about disarmament issues and about other ways how to achieve peace. So I ran there into a problem, but it does not mean that they are not concerned about peace. That's not what I would deduct from it. It was just a lack of interest about the International Criminal Court. Then with regard to your reference to right to life, I was wondering, maybe I misunderstood you, but the Human Rights Committee in its General Comment 6 has already stated many, many years ago that war, unjustified war, is a violation of the human right to life. If you look at what happens to soldiers, what happens to collateral damage, that's not war crimes, it's not crimes against humanity, yes, it's not genocide, but it is the guilt and responsibility of the one who starts the use of force, who commits a crime of aggression. And this person is the one who violates then the right to life and many other human rights that are violated in a war. And I still wished we could convince you. I will not give up trying with it. Then with regard to soldiers, you asked, if we limit this to the leadership position, does that make it harder to be a conscientious objector? I understood your question in the sense, because you can then not argue, oh, I fear that I will be prosecuted for the crime of aggression. You cannot argue this right now either, and you still remain as a conscientious objector free to argue that you find this particular use of force wrong. I did not see that our concentration on a leadership position would make it more difficult for soldiers to object. With regard to the manifest clause, we need to also keep in mind that it had a policy role as well, and that was with regard to the issue of non-prejudiciality. When we discussed what we do about prior determination by other organs, be it the Security Council or the International Court of Justice, no matter if they would be required in the jurisdictional conditions or not, should those determinations be prejudicial and binding on the International Criminal Court? And we came there to the conclusion, no, they should not be binding due to the rights of the accused. The accused should be able to not just argue mistake of fact or whatever. The accused should be able to argue this was not an act of aggression. Maybe the accused has evidence that was not considered before. The accused is not heard in the proceedings of the Security Council or the International Court of Justice. But the moment you agree on non-prejudiciality, you have the policy problem in international law that you may have conflicting determinations. And there the manifest threshold clause serves a function, an explanatory function. You do then later not have to necessarily say, oh, we came to a different conclusion with regard to the definition. You can say it was due to the higher evidentiary standard, it was due to the manifest threshold. I just wanted to throw that in. In a way, the manifest threshold clause applies the standard of beyond a reasonable doubt to the act, to the state act itself. Then with regard to the question why we didn't put in purpose and motives and gravity and whatever into the second paragraph of Article bis. One explanation I mentioned before, when France, for example, gave in with regard to putting in a threshold, they were at the time arguing it should be only, if we don't do it in a jurisdictional fashion, it should be only in the first paragraph, because they did not want to touch on whatever the concept might be under the Charter. And the United Nations Charter does not say anything with regard to gravity or with regard to purpose. There it's just a question what is prohibited or what is not prohibited. At the same time, we kept the reference in the second sentence of the second paragraph to 3314, and that can be again how should I say, a line to what you have in 3314, where it says also that not all uses of force are acts of aggression, so that can be helpful. But you have it in the first paragraph. I've often wondered if we should have shifted into the second, if we should have divided the legal questions and the factual questions with regard to act of force. I feel, I was at the time arguing, if we had put it into the second paragraph, it would not have necessarily affected the definition under the UN Charter, because the definition under the statute is for the purposes of the statute, and under Article 10 of the statute, what we do in the statute does not influence what is happening elsewhere. But as I was just mentioning, others were too worried about it and wanted to leave it as close as possible to the United Nations Charter.
But they didn't bring in Article 51.
They did. Because you say that you say that that the use of force has to be inconsistent with the Charter. And since self-defense is permissible under the Charter, therefore anything under self-defense is anyway protected. Does not fall under inconsistency with the Charter. There you have more the question, what falls, what you were mentioning, what actually falls under individual and collective self-defense. But in principle, those cases are definitely excluded because they are permitted under the UN Charter, and therefore such uses of force would not be inconsistent with the Charter.
Thank you.
Yes. Shall I use the... Is this working? Yes. Very briefly on the conscientious objection point.
I meant duty to manifest. I meant, sorry, duty to disobey and manifest. That's more than one.
Okay, whatever. I fully share Jutta's views that nothing will change in most national legal orders because of our definition at the international criminal law level, because most national laws, all I am aware of, are not referring in that respect to what international criminal law says, but the standard, the yardstick is international legality as such, and this standard remains unaffected by the fact that individuals cannot incur, ordinary soldiers cannot incur international a criminal responsibility. So I don't think you should be worried at all. Second point, and that's a very interesting and a fundamental question you asked, should one not have taken a fundamentally different policy approach and hoping that the gray area, the existence of which does not seem to be denied by anybody here, should one not have hoped that the ICC is the instruments to clarify, to progressively develop international security law? That's, I think, a difference that goes down to the philosophy of what criminal law is about and should be about. It is my firm belief that international criminal justice, much more even than national criminal justice, but I would apply that to national criminal law basically as well, is such a peculiar instrument, the sharpest instrument, also from a human rights perspective, the sharpest instrument a public order disposes of, that it should only be used, should be applied narrowly, cautiously, and it should only be used in cases where the primary norm, the rule of conduct, is clear in the given society and is not open to a fundamental dispute and controversy as we have it in the international legal order in this area, without any hope that it will be clarified soon through an interstate body, at least as I am concerned. To clarify those basically interstate disputes through criminal law, case law, on the back of the individual leader, I think would be a fundamentally flawed approach and would put the whole enterprise of international criminal justice, this very delicate instrument. We are still, don't forget this, at a very early stage of this renaissance I mentioned yesterday, 1990. It's very vulnerable. It would be put at risk in the international reality. You're right to say the ICTY has been, and others following, they have been somewhat more audacious in areas of international humanitarian law. I would accept that there was probably a time after this renaissance where, to an extent, an atypically, call it progressive, stand was unavoidable to get the development going. But I think we have long reached the stage where international criminal tribunals, be it the ICTY or the ICC, should be very cautious. And the many decisions states have taken in adopting the Rome Statute should also be, by these tribunals, these very progressive tribunals, should be taken as a word of caution. I'm not talking about the crime of aggression, just take some of the elements of progressive jurisprudence in the area of crimes against humanity, where the ICTY has, in a surprisingly superficial manner, without any judicial reasoning that deserves being called judicial reasoning, abandoned the policy requirement in a hidden footnote in Kunarak. You know what I'm talking about. This is a way of pushing the law forward that states at times simply don't accept. And Article 7(2)(a) of the ICC statute is a clear rejection of this approach. There are, take another decision in Kupreskic, a textbook case of a so-called progressive development. The idea that the prohibition of using reprisals enshrined in Article 51(8) AP1, Additional Protocol 1, is also part of customary international law against a clear-cut reservation clause by the United Kingdom and other states, by broadly referring to the Martens Clause. This way of trying to progress international humanitarian law through jurisprudence is dangerous for the enterprise of international criminal justice in general, I think. And therefore, in this area of crime of aggression, it was right to accept the existence of fundamental controversies that are unlikely to be resolved in the near future, and not to overburden the international criminal justice system with resolving those questions, and to just open up the challenge critics are waiting for to make. This is a politicized institution, because that would be inevitably the consequence, and it would cast a heavy shadow of doubt on the institution. On Davis' points, which were very good and difficult to comprehensively, so it doesn't seem that you had not prepared your speech. It was quite well done. I apologize for not being able now in 2 minutes to give you a full answer.
You've already given me a very good answer in his response.
Okay, thank you. It's true, neither humanitarian intervention nor anticipatory self-defense, and I could add other cases. Professor Morris referred to whether or not self-defense is applying in cases of non-state armed attacks, forcible rescue actions, in case of, all these questions are not specifically addressed in the travaux préparatoires of the Princeton process, for example, just because at a very early moment in time, delegates recognized this would not be the forum to conduct, so to speak, a textbook discussion about the controversial areas in international security law. It was very early, there was a sense, a feeling that this would take the negotiations nowhere. Would we start to discuss? There was no mandate to do this, and the group would not be simply the right forum to do it. And this, because you asked me what happened to the United States proposal in that respect, this also is the basic explanation why, in the end in Kampala, those cases have not been explicitly mentioned. There was, and Todd, please correct me if I say anything which is not entirely accurate. The United States wanted to go a little bit further and really list, to a certain extent, cases like even clear-cut cases of self-defense which are not covered. And when I checked then in my capacity as a focal point the mood of the room to see whether there are reasonable chances to, and to what extent there are reasonable chances to reach consensus, it was not the case that all those American suggestions were rejected by delegations on substance. Nobody would have, for example, disagreed on substance with the idea that, of course, cases of self-defense are not included. A very widespread feeling was, we are 2 days before the end of this exercise, in the full fledge of a hectically concluding conference with a main focus on very intriguing different questions to which we will move on. This is not the moment in time to really try, in the form of understandings, to define this gray area and the boundaries of this gray area in reasonably precise terms. To deal, for example, to come up with a reasonably acceptable definition of humanitarian intervention. There would have been huge risks that we would have not found in this very short lapse of time, with no expert discussion, no transparency, that we would have come up with an insufficient, unelegant, or perhaps misleading definition, and we would have caused problems for the development even on humanitarian intervention in the years to come. I think this is the key reason, despite all remaining controversies about the substance of humanitarian intervention, that the feeling was it is wiser to not mention that specifically. And your ensuing question, the gray area, how do you know? This is a basic point which very much comes back to what Noah said and I alluded to yesterday. Of course, you can take a radically skeptical view like Michael Glennon, saying there is no hope whatsoever to identify anything with certainty in the area of the use of force in its exceptions. If you take that view, that premise, then indeed...
For the record, I don't take that...
No, I'm not saying you. If one takes that view, then indeed, starting from that premise, the whole exercise is flawed, and also the manifest qualifier must be inherently indeterminate. But what is underlying the decision taken in Kampala is, and I think a very positive agreement of states, that the indeterminacy of the law is there, but it is not unlimited. And that it is possible, and now answering precisely on your question, how do you know that it is possible on the basis of accepted methods? We are, after all, I think, trying to be guided in our legal analysis by methods, and why should we not be hopeful that these methods can be applied in international security law as well? We are all writing books on this area, and my basic point is, if you look in all international law books of reasonable standard in this area, you will find in one book after the other the same controversial cases highlighted with arguments pro and for, and then the conclusions of the different authors will differ. But that, for example, anticipatory self-defense in the way clarified by Noah is a matter that under existing international law is open to different assessments by reasonable international lawyers, both using valid international law arguments, I think is hard to dispute. What I agree that whatever term you choose, and of course also with this term manifest, there will in the end be some borderline cases. Of course, there will also be some borderline cases on manifest. To ask for a legislator to completely eliminate borderline cases means asking the impossible. But here again, we are not without methodological help. For example, and this I stress will be an interpretive device in those ultimate cases of uncertainty. We have Article 22, second sentence of the ICC statute that clearly, and in this spirit I've just mentioned, that clearly encourages the judges in an ultimate case of genuine doubt to take the definition which is more favorable for the accused. Again, an argument, a legal, valid, methodological argument to which you judges can resort. So the indeterminacy, without ignoring it, it will be, and of course as the judicial process evolves even more, this is my belief, it will be able to reduce it to an acceptable degree. The final question that you asked about leaders' intent and what role this might play, this is perhaps to my mind for my future academic work the most fascinating question you have posed, whether there is in interpreting the character element of the threshold requirement still a room for attributing some importance to the, you call it leader's intent, I called it collective intent requirement, but it would be hazardous now at this early stage to already pronounce an opinion on it. This will be an area for very careful reflection. I'm just saying it's a very important point you made. Thank you.
You had a quick reply?
Yes, and I promise I will make it quick. And it's a very powerful response to my question. But let us be clear on some of the premises that your response is based on. One is that some agreement is better than none at all. The second premise is that by passing the buck on whether the special working group was the proper forum for legislating on these kinds of questions, but by
Okay, I just needed to clarify because Jennifer equated my position with that of Michael Glennon's. I can't be more clear. My position is that the crime of aggression is determinate. His position is that it is indeterminate.
I didn't mean to, Noah.
Yeah.
I think I was endorsing, I was endorsing your criticism and just noting to the extent you're using the word gaps, which I think was his word.
Yeah.
I think Klaus has explained how the gaps has been filled by the word. By gray areas.
Right.
By gray areas.
Okay, thanks. Right. Yeah.
Sorry.
My choice of the word gaps and ambiguities comes from Duncan Kennedy's Critique of Adjudication. But the idea here is that determinacy is in the eye of the beholder. So, according to legal realist position, or one legal realist position, all of law is completely indeterminate, and someone who's proficient at reasoning can begin from one premise and draw contradictory conclusions. Under that idea, then everything that we're seeing in terms of the basic criminal law is somehow a farce, and that the judges are all using law in order to advance policy positions. I don't believe in that. That's even more radical than Michael Glennon. On the other side, on the other spectrum, is that the crime of aggression itself is completely determinate, that a good judge, a Herculean judge, could follow the methods of international law and come to one best decision that would be incontrovertible. And I'm more moderate than that. I don't think that is true either. I think that probably there's a slight range of decisions that would be acceptable under the current methods of international law. But I could not agree more with Klaus that there are methods that are acceptable in international law among the main establishment of people that determine what's legal and what's not legal, and that those would guide us to a correct decision and right up to the point of the gray area. And at that point, all of the decisions that a judge would take in response to Davis's claim would need to be transparent, would need to be reviewable by an appeals court, could be shut down by the Security Council if they interfered with international peace and security under Article 16 of the ICC statute. And the risks are not as grave as they've been made out to be by Professor Glennon in his article. So on that, I'll just conclude.
If I could just add one sentence, and that is exactly because the court has to establish that it is a manifest violation, the benefit of doubt with regard to indeterminacy goes to the accused.
I'm sorry we're going to have to end the panel now. We've already run quite far over the allotted time, but please join me in thanking Professor Morris for moderating and our excellent panelists, Professor Weisbord, Dr. Kress, and Ms. Bertram-Nothnagel. At this time, we will take a very quick break. We have refreshments in the hallway. Please help yourself and bring them back in with you, and try and come back in about 10 minutes so we can get going again. Thank you.
Good stuff. Yeah, I was worried that some people would be lost by that. It's very technical, all the details.
Different pieces how we fell off the train at different points.
Yeah, I fell off the train at points. Anyway, Klaus, thank you so much. I loved your talk.
It was very good fun too. Very good discussion. Will you be staying today? Or you leaving?
I'll stay at least for the next.
Yeah. Are you getting interested in this area, this crime of aggression area? Are you envisaging writing upon it?
Right, but I mean, to some extent, because I'm writing right now on counterterrorism stuff, so naturally it overlaps.
Yeah.
That, very fortunately, just by coincidence, I'm writing part of that chapter right now. So it's, yeah.
Fits in quite well.
Yeah, it's really, I've got so many things that I wonder about. Like, if you've got necessity fulfilled for self-defense, but there's a claim of disproportionality.
Well, that's interesting. But
per se not manifestly unlawful because proportionality is more.
I think this question would broadly be on the same conceptual level as making criminal law judgments on disproportionality in the area of use invalid collateral damages. Again, consistent with my position would be, and I think it is a position that is more and more getting accepted, that it is only outrageous cases, really, that should be criminalized. And that, so to speak, this margin of legitimate controversy, where perhaps a court on the level of an interstate dispute would come to the conclusion disproportionate and perhaps a basis for compensation, that this is simply not enough for international criminal law. And I think here the manifest qualifier goes even some step further.
Because he was very open to it, and we had wonderful conversations.
And again, we received a lot of
yeah, I look forward to seeing him.
It's interesting.
Scholars saying, well, you are
on their law 4 days.
Precisely.
When they're more progressive on their criminal law days.
Yeah.
Oh.
But the policy itself.
Not in the team as it was.
Criminal law purposes, these safety nets are
Suddenly Human Rights Watch
so I cannot.
No, sorry. I meant
Oh, because the team, as we started,
basically one of the self-defense
to get this done.
Turns into a case of criminal responsibility just because of a judgment of this problem. I cannot imagine.
No,
because usually in these outrageous cases, you are in a situation, I assume, that it's not actually self-defense what the state has in mind, or that initial self-defense action has turned into something different. What is, I don't know what you think, what is quite an interesting case in that respect is perhaps the Russian-Georgian war, where one might have, at least on one reading of the facts, I think still the facts are not clear, but if one accepts the factual premises of Russia, there might have been a reasonable case for a limited action of self-defense for some moments with regard to their peacekeepers, on the basis of their facts. But to portray what followed, still as an action of self-defense, with these massive destructions all over the countries, this I find difficult. This is probably more a case where an initial self-defense action, if it were, then really converted into an action of punishment. I don't know how you...
Which may tend to happen. I mean, because I'm thinking these days about counterterrorism, that's what I think about.
Yeah.
So, what I'm really honestly perplexed with is in counterterrorism, how would you... It's not usually, I mean, unless you've got a harboring regime, then you look at a more traditional use of force.
Yeah.
But where it's not a question of a harboring regime, nobody knows what's necessary because nobody even knows what works. So I don't know how the necessity, much less proportionality analysis would even proceed where there's a claim of self-defense against, you send some predator drone for one guy, and there's a certain amount of harm that that particular guy would be likely to do, or particular harm that could be prevented by targeting that person. But is it necessary? Is it proportionate? I don't know, even at the, I don't even know we can identify the military objective, the military advantage that would be gained. We can't even do that. So how can we then?
But would one not, even under general principles of self-defense, even in criminal law, would there not be, if you are in a self-defense situation, so to speak, a necessity presumption to quite a long way? Would you not give, again, so to speak, the benefit of doubt or the rather wide margin of appreciation to the person attacked, and only rule out the self-defense justification, so to speak, in cases where it is rather clear that it was unnecessary? I don't know, how do you do it in American law? We would be very favorable to the person in a,
But take this guy, where's he's in Yemen, Sorry to interrupt.
of course, we have to, of course.
We need your seat.
You see, we enjoyed it so much that we keep that occupied.
I'm glad to see that.
I take that with, yes. Okay.
Oh, I'd rather doubt that.
We've now officially had something about the subject. I mean, that's somewhat of anticipation. I'm delighted.
Why do I find that equally involved?
Make me feel like I did something. I'm trying to do my presentation very short. I just have 2 pages of notes, which is 10 minutes.
Is that your bag?
No, I have no. Okay, great. Which is actually sort of true.
If I could have